from this computer. All right, so welcome everybody to the November Zoom on disability benefits with Victoria Powell. And Victoria, when did we meet? 2010, 9?
Yeah, somewhere around in there. I was trying to figure that out earlier today because of that little blurb thing. But yeah, it was back when it was still with Cheer, and I don't know.
Yeah, well, anyway,
15 years ago, something like that.
It's been a while. It's been a hot minute. And so Victoria, a couple months ago, I was like, oh my gosh, I've been getting so many questions about disability stuff, and I'm always referring them to you. Would you ever want to put together a presentation on this? And she was like, of course, even though she's like quadruple booked every single day about, working all day long, and then she's willing to put this presentation together for us. So I'm really excited that she's here to talk about this, and she, take questions at the end. I think originally she was planning on just talking and taking questions, but then she decided to put together a PowerPoint at the last minute. So it's fabulous that we've got this resource, and it's going to be recorded for anyone that might not be able to attend. But Victoria, I will let you give a little bit more, background about yourself and your history and expertise, and then you can launch into the presentation. You should be able to still share your screen. But
okay, awesome.
Take it away.
So essentially, yes, I agreed to do this because Sean's so sweet, and I always want to help out. But I would have to preface this by saying I am not a disability expert. I know bits and pieces because of the type of work I do in my regular job. So I did throw together a PowerPoint because it is kind of complex, and I just wanted somebody to have something to refer to. The information is as updated as I could get today, but things always change, so keep that in mind too. So essentially, I'm a registered nurse. I am a case manager, and I am a life care planning expert. So basically, I work with injuries all day long, not just amputations, but that is where my first love is, in the limb loss community. Many years ago, I had a lady who got her hand in a press at work. And that was my first exposure to the limb loss community. And I was just blown away with the technology. And my brother happens to be a prosthetist, so I've kind of been able to get into kind of the background of limb loss. And I just said, hey, he told me that most case managers don't even go to prosthetic appointments, and they don't do therapies and stuff with their patients or go to the therapies. And I thought that was really a disjustice. So I just wanted to learn all I could. So I've kind of just made myself a bit of a pest as it relates to limb loss, and kind of put myself anywhere a therapist or a prosthetist or a patient or anybody might learn something about the limb loss community. But today we're going to talk about disability, and this is called Disability 101 because it is just an overview of disability. Let's see how, it's not moving. Hang on. What's going on here? There it goes. Okay, so there's basically two different programs. These are very complicated, and people get them mixed up all the time. So we say SSD, and we mean Social Security Disability, or we say SSI, which is even more confusing because it's really SSDI. So most people will shorten it to SSI. That's a different program. So the long and the short of it is that the SSD is a Social Security insurance. So basically, the government is an insurance company, and it is funded by Social Security taxes. You can only be eligible for SSD benefits if you've paid into Social Security taxes. So if you've never had a job, you've never paid into Social Security, you will not be eligible for SSD. SSI is a compassion program. So this is more like food stamps. It is based on income, and it comes out of a general fund, and you're eligible for these benefits regardless of your work history if you meet the income sources. Believe it or not, Social Security is not a judicial process, but it feels very much like one. Essentially, it's a non-adversarial system that feels very adversarial. It's actually a statutorily created administrative process that starts when you apply for Social Security. When you say you can no longer work due to some type of impairment, then you can file a claim, and it starts the process. The government, however, their vested interest is really on you paying into the system. So they want you working. They want you paying into Social Security. Therefore, proving that you cannot work ends up being an extremely difficult situation, and you're kind of behind the 8 ball when you get started. One thing to remember is that 64% of first-time applicants are going to be denied. So right off the top, you have less likelihood of getting approved for SSD benefits, just because of the factor that you're trying to prove a negative, essentially, and the government doesn't want you to get SSD benefits. So there are some steps that you have to go through in order to get Social Security. And one of the main things is, and we'll talk about this throughout the presentation. Okay, well, we'll get back to it.
All right.
So anyway, you want to obtain your own records. And I say medical records, but it's not just going to be medical records. You're going to actually have to collect some employment records and some IRS records and things, but you cannot submit them on your own, especially the medical records. The Social Security Administration is legally required to request your records themselves, but you need to know what's in your records before you ever even apply. So it's going to be important for you to collect your information and build a case before you apply rather than during the application itself. When you actually apply, there is a form, and Sean, remind me, and I will give you an actual copy of the Social Security application and a couple of publications that you can put in the resources too. But when you apply, they're going to be asking you for the names of all of your providers, the dates of your treatments, what kind of treatments you had, what's the ongoing updates, because they're assuming that you're still in some type of treatment. What is your work history? They're also going to give you some forms to complete that have a bunch of questions about your disability. And they may actually send you for an examination. And if they do that, it's at their expense. And then the next thing is you're going to just have to wait. And we'll talk about how long this process waits and how long the wait is and so forth here in a few minutes. But while we're waiting for an opinion from Social Security, you must continue to treat. Now, if you have an amputation, your treatment is either you're wearing prosthesis or you're not, you're going to therapy or you're not. But even if you're just going to your primary care, this is something that Denise Hoffman and I have talked about a great deal with the Amputee Coalition. You need to be letting your primary care provider know how many plies of socks you're in, or what kind of skin breakdown you have, or what is the status of your liner, or what kind of secondary conditions you may have. Do you wear a body power device and now you have shoulder pain, for example? Those kinds of things also make a difference when we're talking about disability. And remember that the burden is yours. It is your responsibility to show the government how you meet the requirements. There are actually 5 steps, and 4 of those steps are your burden, and it's based on your disability and your work ability, past work. And in the last step, the government is going to try to prove that you can work, and they're going to have to prove that you're capable of doing other work in order to then deny your claim. Because remember, that's what they want to do. They want to deny your claim. So a lot of people say, do I need an attorney to file for Social Security disability? The long and the short answer is no, you don't have to have an attorney. It's actually not an adversarial position. So there's no it's not a judicial process. You don't have to have somebody to go and be your support person, whether that's an attorney or not. I can tell you that a Social Security disability attorney does not necessarily get fees. It's kind of, they work on a contingency fee. So, and they have fees that are capped. So there's a potential that it would be beneficial for you to get an attorney. You can always go and have a consultation with an attorney and just see what they can offer you before you decide whether or not you want to do that. So there's an initial application. You can get an attorney at that point. So before you ever even apply, they can help you get your paperwork and stuff together. You can actually have a I actually did some training on this. Anyone, a friend, a neighbor, a nurse, anybody can actually go and be a representative for someone and help them fill out the paperwork and help them through the process. Make sure that you dot all your I's and cross all your T's before you do the application. But you can also use an attorney for that. And then reconsideration, which is be like your appeals process, that's where most people get an attorney. But I just want you to know that you could actually get an attorney before you ever did the initial application. They don't have any sway over the results. They don't have any pull within the system. Really, the benefit of having an attorney is really based on they have knowledge and they know what to look for. So if you aren't a medical person and you don't know how to collect the information or what information needs to be collected, that might be a place to find somebody who would help you. Maybe you're not eligible for SSD because you haven't worked in the system. If that's the case, you might be able to get SSI only. You can hire an attorney for SSI only as well. And you can hire an attorney at any step. You may get halfway through and then decide, oh, this is over my head, and I think maybe I should get an attorney. To kind of give you an idea, most attorneys, all attorneys will take Social Security disability on a contingency fee basis, meaning if I don't win your case, you don't owe me a dime. Then let's say you win and you get your disability. Then there is a statute that says that their fee can only be capped at 25% of the past due benefits, or 25% of past due, or capped by statutes. If you don't have any past due benefits, in other words, they're not paying you retroactively, then there would be no fee. The attorney usually will pay your medical record retrieval fees at their own cost. But then if you win your case, they want to be reimbursed for those. So you would still owe for attorney expenses. Of course, if you did not get disability, you would not owe for those retrieval fees. So one big factor is the definition of disability as it relates to Social Security disability. It is a legal term, not a medical term. So just because a doctor says that you're disabled does not mean that the government thinks that you are disabled. So you're going to hear this word over and over and over, substantial gainful activity. They abbreviate it because the government loves abbreviations as SGA. So they say that a disability means you cannot do substantial gainful activity either due to a medical impairment, a physical or mental, or a combination of those impairments. And it has to have lasted for at least 12 consecutive months or expected to end in death. There's no such thing as temporary or partial disability like you might hear in a workers' compensation case. According to the government, you're either completely disabled or you're not. The disability, not the condition or the diagnosis, has to have lasted for more than 12 months. So this is about a severity of your condition rather than just having the presence of the condition. And symptoms do not equal impairment. So it doesn't matter how bad your symptoms are, how bad you hurt, what you can and can't do from a symptom standpoint. It is all about the actual impairment itself. So who's eligible? SSD is different than SSI, remember? So in this one, this is not needs-based. So it doesn't matter how many assets you have. It does matter if you've worked. So you have to have 20 work credits. One work credit is 1 quarter. So over the past 10 years, you had to have had 20 individual quarters. So 20 quarters over the past 10 years. And then your quarter earnings must equal $1,640 or more per quarter. So every 3 months, you have to have earned at least $1,640. And you have to be paying into FICA taxes, your Social Security tax system, which is your FICA. Where we get into trouble with this is some people are self-employed and they may not pay into FICA because they're self-employed. That will automatically wipe them out and not allow them to be on SSD. You also have to be diagnosed with a condition that prevents performing what we would consider basic work activities. And your payment's going to be based on the amount of lifetime earnings. So the more money you earned, the more your disability benefits would be. I have executives who have like congestive heart failure or some kind of significant cardiovascular thing, and maybe they were a salesperson or something. And I have some of them earning $5,000, $6,000, $7,000 a month in disability benefits. So it just depends on how much they made. So who's eligible for SSI? Remember, this is the compassionate program. So there's no work history required. It is a free benefit, but it is much lower than SSD. It is needs-based, and they must pass a means test. So that means is like your financial means. So they are taking into consideration spousal income. They don't take all of it, but they do take a percentage of what your spouse may make. They take in the monetary value of food and shelter that is provided to you. So like if you're single and somebody's letting you live in their house, your, extended family or something is allowing you a place to live. They'll take into account any kind of part-time work you're doing on any resources that could be sold. Now, they're not going to make you sell your vehicle if you only have one vehicle, but if you have two vehicles, they're going to take into consideration that the amount of one of the vehicles because it could be sold. And then the federal benefit rate, this is the FBR. This is also, you'll hear the FBR when you talk about things like SNAP benefits and things. But if you are an individual, it's $914 or $1,371 for a married couple. So that anything below that would allow you to have benefits. You have to have less than $2,000 in assets if you're single, or $3,000 in assets if you're married. And there's a very specific rule. It's called holding out relationships. So you hear about these couples who they aren't legally married, but they live together. They act like a married couple. Their friends and family consider themselves to be married. They share a bank account, and everything but a piece of legal paper, they're married. The government says that's not a loophole for you to get out of this. We're still going to count your significant other relationship, because you guys are acting as if you're married, even if you aren't legally married. So that's a little loophole that people think that they can get, that they cannot get. They'll get around that. You can't get around it. So this one's a little bit outdated. These dollar figures are from 2021, but I just wanted to show you a side-by-side chart. So SSI 65 and above, blindness or disability and limited resources, all these different ways are ways that you can get SSI, where SSD is based on disability and work credits and so on and so forth. Okay, can I work and apply for disability? Yes, but it's a double-edged sword. Now, there's a difference in working while you apply for disability and working after you're on disability. So this is about working when you apply for disability. So substantial gainful activities is going to look at your gross income and not your net income. And for right now, for 2023, it's $1,470. So they're going to be looking at work attempts. So my suggestion is, if you want to work and you're applying for disability, you apply for disability, wait until you've gotten disability, wait 12 months before you attempt to go to work. Because anyway, there's a whole big rigmarole, because if you went to work before your 12 months is up, why did you get disability in the first place? Because you were supposed to be disabled for at least 12 months. Then you can have work attempts. So you can spit and start and stop and spit and sputter, or whatever you want to call it, to attempt to go back to work. And they're going to consider, if you can go back to work for more than 6 months, they're going to consider that successful, and they're going to cut your disability. So if at 6 months, you either prove that your work is not, in other words, you're making money, but you can't earn more than $1,470, or you have to prove that your work is being accommodated or subsidized by your employer. So for example, maybe you can work at a job, but they only have certain things that you can only do certain tasks, and they need far more than those tasks. But when those tasks are available, they allow you to work. So maybe you work for a couple of days here and there, only when they have that task available for you. If you're in a situation like that, then you can get a letter of accommodation or showing that you're being subsidized somehow, and they will consider that. And then an unsuccessful attempt would obviously be where you went, but you couldn't do it, or you didn't earn enough, or whatever. Sometimes it's a matter of you had a job and they were providing some type of assistance and they can't provide that assistance anymore. COVID would be a good example of that. When things changed during COVID and people had to start working from home and things, maybe that wasn't a position that you could do, so that your position was kind of eliminated because of the elimination of the assistance. So what about retirement? Social Security disability benefits automatically convert to a retirement benefit at full retirement age. And some people say, oh, well, I've paid into the system and I can take early retirement. Maybe they're 50, 55, something like that. They want to take early retirement. And you can do that. And it can be very beneficial to some people. But if you're not careful, whatever you take at early retirement could be less than your full retirement benefits for life. And you will be stuck with that if you took it early. So sometimes this is a situation where I would tell you, you need to go and talk to an attorney, because there's so many different factors. Like, they would need to be able to calculate what your disability amount would be. And then they would have to be able to tell you what their disability amount would be, and then what your retirement amount would be if you're retired at 55, at 60, at 65, at 70. And it would make a difference in your longevity. So the steps in the process are basically, are you working? So that's number one. You have to be proving that you're not working. So that's the number one thing that they want to find out. And I have a little note here. Sorry, I was supposed to have this like handy. I'm sorry I didn't do that. So they're looking at your gross wages. They want to see if you're making more than that $1,470 per quarter. So even if you're not paid much, you can still be considered. And then, do you have a severe medical impairment? So at this step, Social Security is going to decide whether you have a quote unquote severe medical impairment. And the severity means it has to significantly limit your ability to perform basic work activities. A medical impairment that has no more than a minimal effect on your ability to work is not considered severe. If it's considered severe, then it moves to the third step. Does your medical impairment meet a listing? So the Social Security Administration uses this thing called a blue book. And in the blue book, they have a list of medical conditions that basically kind of fast track you into disability, and amputation is on there. And I'll share with you about the amputation criteria that I found at the end of this. I just captured some blurbs to share with you. And then the next step is, can you perform any of the work that you did in the past 15 years? So maybe you had 6 jobs in the last 15 years. You have to show that you cannot perform the activities of any of those jobs, not just the job you were at most recently. So maybe you sat at a desk 6 years ago and now you're a laborer. Just because you were a laborer at the time of the incident that maybe caused the disability doesn't mean that maybe you couldn't do the desk job. So they're going to be looking for that. And then the crazy thing is, the last step is the governmental process. And on this one, can you do any other work? And they're not looking at where you live. They don't care. They're looking at the national economy. So if there is a place in, I don't know, California that has a particular need for a particular widget maker that you could do, they will tell you that they can deny you because the national economy has this need for this job that you could do, even though it's not anywhere near the state you live in. Now, there's a little bits of ways that you can appeal and get past that, but just so you know what you're up against. So what do they need to be able to make a decision? They need the objective medical evidence. That's going to be the medical records. They do not, it has to be an acceptable medical sources. So there are some sources they do not consider to be acceptable medical sources. Chiropractic is one of those. Social worker is one of those. Any kind of alternative, naturopath, those kinds of things are not considered acceptable medical sources. your regular doctors, MDs, DOs, some of those are all included, PTs, OTs. But some of these others are not. So you have to have some. It doesn't mean that you can't have some acceptable and non-acceptable. It's just that they're only going to look at those that are acceptable. A medical source opinion, that is a doctor who has written a letter or has filled out a form on your behalf to explain that they feel like you are disabled, despite the fact that your records maybe don't reflect that so much. Or they can send you for a functional capacity evaluation. We do these a lot in the work arena, vocational arena, to find out what you're functionally able to do. And then there's also one called a residual functional capacity, and that's actually the most you can do despite your impairment. So what you can functionally do for an 8-hour workday, and it looks at exertional limitations and non-exertional limitations. And so that's yet one more piece of evidence they can require. Okay, so buckle in, because it's going to take forever. It's going to feel like it's going to take forever to get disability. So the initial claim average right now nationally 165 days. So you get an answer. And I mean, even if you get an attorney, they can't speed up the process. All they can do is check to make sure that it's still pending and, that the information is there, but they can't do anything to speed up the process. If you get denied, you can go into what's called the reconsideration period, which is your first appeal. That takes 5 to 8 months on average. And then a second appeal, 10 to 12 months. A third appeal, a year or longer. And then I've never heard of anybody going, I'm sure it happens because they wouldn't have this otherwise, but I've not ever heard of anybody going to a fourth appeal, which is basically taking it to district court. So you could, okay, I'll go realistically. It's most people go through a second appeal, sometimes a third appeal. So you're looking at 1, 2, 3, 3.5 to 4 years. And people can't function like that for very long. So much less 3 to 4 years. Why do you get denied? Most of the time it's because the medical evidence is not consistent with the level of alleged severity. Again, remember that this is a legal definition, not a medical one. So they are looking for severity. And sometimes we have these really horrible symptoms, or we have these horrible limitations, but yet it doesn't come off that way in the medical record. The other thing would be you didn't have enough work credits. So if you didn't work the last few years, you wouldn't have enough work credits. You maybe didn't wait enough time, didn't have enough time, like your disability wasn't long ago enough, because it's supposed to have been 12 months. So maybe you tried to file disability too early. Or you could wait too long to apply, where you've basically figured out a way around everything. You're not going to the medical record. You're not going to the treaters anymore, or very rarely. Prior denials, if you got a denial at level 1 or in the past, and then you try to go back again, they're going to look for all the information that they denied you from last time. They're going to look for those same things again. Doesn't mean you're automatically going to get denied, but that's one of the things that they're going to be looking for. And then failure to follow treatment. Nobody can force you to have a surgery and invasive treatment if you don't want to. So they can't hold that against you. But if you don't want to have surgery, if that's recommended for you, then you can turn around and there should be other treatments to do. Maybe, okay, you're not going to do surgical, so let's do some type of conservative one. They do consider your compliance with doctor recommended treatment and will weigh that against your reasons for not choosing to follow through with what the doctor recommended. And then working above that's gainful activity amount. Okay, fixing to open this up for questions, because I wanted to fly through this real quick. But this is what I found from the Social Security Blue Book, and it says that if you have an amputation of both upper extremities anywhere at the wrist or above, you're automatically considered to be a severe impairment. Also hemopelvectomy, hip disarticulation. If you have one upper extremity at any level above the wrist and an amputation of a lower extremity above the ankle, and either the need for a walker, cane, some type of mobility device, or the inability to reuse your other arm, that would automatically put you in that process. Or if you lost both of your legs at the ankle or above, and you can't use a prosthesis, or you need a walker or something like that. So those are all what they consider amputation due to any cause. So I pulled what they considered in an evaluation. So they're looking at the amputation itself, the cause, and then they're also looking at in the upper extremity, if you've had them, they're looking at if it's below the wrist, they have different rules, and all these little blue things are links that you can go to read the actual governmental data on what they do. So I put those in there since we are at Skills for Life, so you could see those. And I'll open it up for questions, or you can tell me your stories, or I'll see if I can help.
Thank you so much. That was very, very helpful information. Yep. Let me, Victoria, do you want to unshare your screen, and then we'll,
Oh,
if
yes.
people want to
Please do that.
turn their camera on, they can. If they don't, they can just ask the question. But we did get rid of the person.
Porn star or whatever it was.
And then I think the question, if anyone has any questions, I think it's still helpful to keep the recording going. So I'm going to keep it on for now. But if no one has any questions, Mike, you've got a question.
Yeah, not so much a question as it is a comment. I apologize for not having my camera on. I can't figure out, my computer fell out of the desk that it's in, and I don't know what's up with the camera. But here we go. So, yeah, there was a lot of great information in there. Some of it kind of correlates to when you go get a handicap placard, that if you're missing some kind of bilateral upper extremity issue, you can automatically qualify, or if it's such a high level lower extremity, you can automatically qualify. And I really appreciate, like, for me, what I took from that was the number one thing was document, document, document. When you go see your primary physician, like, they got their notes, but you need to keep your notes, and you can request their notes. I've been not denied SSDI or SSD or SSI, or, because mine was such a traumatic kind of situation, missing all four limbs. But it's helpful to keep that documentation so that when anything ever happens, you've got your records rather than memory. So when I go see my primary care physician, I'll put a note in my computer, or I'll make some kind of note or document that says, I'm going to see this person because, and then this was the resolution from that visit, so that when the insurance company, which
which is a
really,
whole other ball game that still needs the same information. Absolutely.
Yeah, I mean, I don't mean to be negative, but in a way, their job is to deny,
yeah,
so that they're not paying out. Our job is to document so that we can get the care that we need.
Yes. So Mike, you're spot on. And in this particular case, you do need your records. You just can't turn them in. But what you are doing is you're actually collecting, let's say you're treating with Dr. Jones, but 6 years ago, you treated with Dr. Smith. If you don't remember that you treated with Dr. Smith, then you're not going to tell SSA that you also need to get records from Dr. Smith. So maybe it was Dr. Smith who was there at the initial time of your disability, and now Dr. Jones is just kind of following up. Well, the problem is Dr. Smith is going to probably have the better records than Dr. Jones will, because they were there at the time of the disability. So as it relates then to the insurance end of things, I'll go back to the Amputee Coalition. The First Steps book, which is free, has pull out sheets in the back of it that we designed in order for you to remember how to talk to your doctor. And it's actually a fill in the blank kind of thing. So what we found is that if you don't tell them what to document, what's important as it relates to limb loss, they will not necessarily document it. So you need to be the one to explain that this is how many plies of socks I'm in. You don't may necessarily need a new socket right now, but if you can show that you're having more and more and more plies, that puts you at need for a socket. So we're showing a trajectory of care. If you can talk about your secondary pain complaints from altered body movements, that's another reason that we're documenting that. So the doctors need some help. And unfortunately, what happens in disability is you have this impactful disability, you're financially ruined, you need help now. You hurry up and you apply, and things fall through the cracks because you didn't dot all the I's and cross all the T's and get all of the medical information that was needed before you applied. And then you end up getting denied and having to go to appeal. And you may get it on appeal, but you've wasted time that perhaps you could have saved yourself by getting all of that data taken care of in the beginning, making sure that your records are clean, requesting those records. And honestly, these days, I would request my records all the time. Anytime you've had any kind of a significant event, an MRI, a CT, anything like that, because records are notoriously wrong. They're using voice dictation. Big, huge hunks of information is either wrong or cannot be interpreted or can't be interpreted, later on. So it's very, very important that you control what's in your narrative.
Yes, I'm trying to figure out what year it was. No, it was last year. I fell and I hurt my right shoulder, and my primary said, okay, well, go, get physical therapy, go get an x-ray, do this, that, and the other. But the notes said left shoulder. So when I showed up for the x-ray, physical therapy, they could not do anything because it was the wrong shoulder that was annotated in the records. And I had to go back to the primary, get the proper shoulder annotated, and then move forward from there. So yeah, everything that you're saying is 100%. Like, yeah, keep your own records so that you know what's going on. And if there is a question, you can go to the responsible party and hopefully try to correct it.
Yeah. So, hey, I know Jimena has her hand raised. Thank you, Mike. I wanted to mention the kind of irony, or maybe it's not irony, but the fact that you started off the presentation by saying it's non-adversarial, like it's,
But it feels very adversarial.
Yes. All right, Jimena.
Thank you. Just wondering what your thoughts are about whether or not a parent should apply for a minor or dependent to get SSD.
Okay, so I knew this question was going to come up, and so it has to do with work credits. So if you're talking SSD, it is work related. So they had to have worked those 20 quarters. If their disability was before they were eligible to work, then they should not be eligible for SSD, but they would be eligible for SSI. As far as applying for them, yes, if they're absolutely, you should be able to apply for any benefit that you think that you can get on your own. That's a needs-based, not a work-based. And then, Amanda, let me share something else too, which also might help you. One of the things I meant to mention is the Ticket to Work program. So I said, if you're going to try to work, you should wait until you've been on disability for 12 months. There is actually a program called the Ticket to Work program. You have to actually you have to find somebody who knows something about the Ticket to Work program, because a lot of people don't know about it, or they think they know about it and they don't do it correctly. But essentially, it's a program that Social Security and SSI disability beneficiaries can get help with training and services to allow them to go to work, and it's at no cost. So what they're trying to do is they are trying to take people who would be on SSI. So in other words, it's a compassion program, government's paying for everything, and they're going to try to allow them to do some form of work so that they can pay into the system. Because even if they're able to work just a little bit, it's they can pay into the tax system and help the government out. So there is you can go through a provider that agrees to work with them and get these kinds of work things. So to give you an example, I have a girlfriend, she's deceased now, but it was a girl who had metastatic breast cancer. She was an attorney by trade. Due to all of her medical treatments, chemo, radiation, all the things that she was going through, there was no way she could consistently work. She could no longer participate in the law firm that she worked for. So she was able to get on, she was actually on SSI because she was poor and didn't have anything by the time all of this occurred. She ended up doing the Ticket to Work program, and she was able to work as an attorney from her home. She took one case at a time. She did criminal defense because it's all paid up front, no contingency fee or anything. So she would take one case at a time. If she felt like working, she'd work. If she didn't feel like working, she wouldn't. And then because she was self-employed, she was able to take all of the tax deductions and show that her income was very low. And that's super beneficial to people on SSI. There's also a thing called an ABLE account, which stands for Achieving a Better Life Experience. And it's a tax advantage savings account for those with a disability. And these are ones that the disability, the SSI or disability or blindness has to begin before the age of 26. And this would be somebody on childhood disability benefits or disability insurance benefits, disabled widows, widowers, things of that nature. And you can put this money in an ABLE account up to $100,000, and it does not count against their financial rules. So you could actually set aside that money, put it in an ABLE account, and the government cannot use that as income to deny them SSI benefits. So those are two things that if you're talking about a kid, I would definitely look into those.
Thank you.
And that reminds me, Sean, I've got a flyer on those two. I've got the governmental downloads for those two.
Yeah, just email it to me and I'll get it
Yep.
uploaded. Include links. Any other comments or questions?
Leanne, you're muted, I think.
Am I muted?
There you go.
There you go.
By the way, hello, Victoria. It's good to see you again.
Hello.
So can you explain how a inheritance would affect either of those? Say a person is receiving either one of the benefits, and then they unfortunately a parent passes away, and there's either a smaller amount of money that then is handed out. So how would that work, and what could someone do to foresee caring for themselves that way?
Okay, so this is one where I would ask an attorney, but my gut is telling me that you could be the money from the inheritance could be placed in either a trust or potentially that ABLE account. So you still have access to the funds, you could still use them, but they would not count against you. And a trust, usually the trust has to be like, let's say Medicaid trust. If you have Medicaid benefits from your state, then you can put funds into a Medicaid trust at a bank, and you can use those funds for anything that Medicaid would not pay for that you need. So if I do special needs trusts all the time for birth injury kids and things, and what'll happen is the kid is severely, profoundly disabled, needs a ton of therapy. They're on Medicaid, they get a few visits per year, and it's not near enough to take care of the child, or maybe they need a special car seat or even a car modification to put them in a particular seat or something. Medicaid doesn't pay for those, or maybe they outgrew their chair and Medicaid says it's not time to buy a new chair yet. You can use those funds then for those kinds of things. You just have to exhaust. The point is you want to keep your Medicaid benefits intact. And so we want to use Medicaid benefits until we can't use them anymore. And then we want to tap into the fund and then let Medicaid pick up again when it's time for them to pick up again. Does that make sense?
Yes.
So because it's an inheritance, I know that with special needs trust is if the money comes into the family household, it automatically stops the Medicaid benefits. So that money cannot pass in through the hands of the household. It has to go directly into the trust. So that's something that could actually be set up in a will or whatever, that when they go to disperse the funds, that it goes directly into a trust that's already has a name or, you know, set up.
Okay, that's good information.
But it looks like you could also use this ABLE account too. So I just don't know that much about it. I've heard about it. I was able to pull off a little sheet on it, but I just don't know all the ins and outs of the eligible. I know that you can be eligible for SSI and then you can put this money in the account, but I just don't know how it gets there. It does say it can be used for education, housing, transportation, employment training, employment support, assistive technology, and related services.
So much good info. Are there people out there, Victoria, that specialize in helping people fill out an application that won't get denied on the first try, or if they've got denied, they can help them on the appeal process? Like, do you do that, or does anybody else do that for a living?
So yeah, the answer to that is yes. That's actually how I got into it initially. Is I took a legal nurse consulting course where they were explaining that we could go and be that person for someone, and it was people who were kind of, you know, in the helping industry, and it was a way to help people. And then once they got their disability, if they did get disability, you would get that 25% of that fee, that statutory fee. It wasn't a lot of money, but it was a way that you could help people and do that for them. But there's not a lot of people. Okay, so anybody can do it. You could go have your friend help you with your paperwork, and they can go and be your representative in front of Social Security. However, finding somebody who's knowledgeable about it is another thing. So how do you find them? Honestly, I'm not really sure. I know that our company has a patient advocacy department. This has not really been, we do a lot of Medicaid apps and things like that, but we don't necessarily do Social Security disability. We've just never gotten into that before. Frankly, we're really busy with what we have going on, and that's another whole thing to have to learn. But I would probably start with patient advocacies groups. But honestly, if you even hire an attorney, I would love to tell you that you're actually going to talk to your attorney and your attorney's going to know everything, but that's not really the case. It's really somebody trained in their office who's a paralegal or legal secretary who's case managing the file. So. But as far as all the other things, as far as like filling out paperwork for, you know, Medicaid, managing a trust, those kinds of things, there's lots of people who do that kind of stuff, us included.
What's one of the questions you feel nobody ever asks that they should ask?
As it relates to what, Leanne?
To the bigger picture of making sure you fill out the documents, or
Oh my gosh, there's so many. Like if you were in jail, like if you went to jail, that's a deal. If you have some kind of felony, you're out. Those automatically deny you. You could go through all that paperwork and then find out that they find out that you were in jail for more than 30 days and then you lost everything. And I realize that that's not the big part of the population. The biggest thing is and let me say this too, when you get your paperwork, whether you are awarded disability or not, you don't get a notice as to why you were awarded disability. So just because your friend down the street has disability due to a back injury and you have a much worse back injury, doesn't mean that they got disability on their back injury. They actually could have gotten disability on a mental impairment, not their back. But yet the back was another part of their disability. It was a combination of factors, if you will. So you don't know why you got awarded. Now, when you get denied, you usually have a reason for the denial. But when you get the award, you don't know. So when you go back to asking that question, it's a matter of not having in the medical record how this is really affecting you. So when it comes to, say, amputees, limb loss community, obviously, Leanne, somebody can look at you and see that you're a very capable person, but yet you're missing your limbs. So that one's pretty obvious. When you go to the doctor, they know you're missing your limbs, but if you were, just because you're missing your limbs doesn't mean that you aren't eligible to work either. Now, I always recommend that if somebody wants to work, that they're going to try to find some kind of self-employment thing to do. Maybe they make widgets on the side and they just make a little money here and there, or work when they want to. Anything that they can do to take those tax deductions and use them to your advantage and write off as much stuff as you can. Not everybody's able to do that, but that's a way to get a lot of bang for your buck if you're going to have to be on disability. I talked all around that subject, but hopefully that helped.
Great answer. All right, well, if there's nothing else, but you guys, the Victoria's email address was on that last slide, and I can send it out again, or
now you can contact me via the board.
yeah. Oh, that's right. So Victoria just joined our board of directors at Enhancing Skills for Life. So her first board meeting will be the Tuesday after Thanksgiving. So we're excited to have Victoria join us.
Mike, thank you.
Okay, so then yeah, I will let everybody go 2 minutes early, and thank you again, Victoria, for putting this together. I know you didn't have time really to do it, but I'm just so grateful for the information sharing. So thanks again.
No problem.
Yeah, it was awesome.
Thanks.
Solid. Really, really good.
All right.
That's all I got.
All right, good night, everybody. Thanks again for coming. I'll get the recording link posted soon.
Yeah, and Sean, give me a few days and I'll get you all those resources.
Okay. All right.
Thank you.
Bye, guys. Bye, Jimena.